So, very good evening to all, and it's our profound privilege to find these resource persons for our, webinar. And I mean, the theme of the webinar is a very thoughtful selection by the students, that is judicial responsibility in enforcing second and third generation rights. So to bring something, to set the background, I'm not that much able to speak upon that, but I will just, to make a sense that what we are going to discuss about. So as you know, why we have chosen only second and third generation of the rights rather than, taking all the three. So that may be one of the reasons which clearly shows our attention to these two rights, because as you know, the right to life or any other rights, civil and political rights, they are pretty catchy to the media, to other people, and they are being covered in a very inclusive sense. But these two rights, economic, social, and cultural rights, and third generation rights like right to environment, right to development, or right to sustainable development, these are sometimes left apart. They are recognized, but how they could be enforced, that is the real challenge. So because of that, we need to pay heed to these two generations of rights. And while saying that, we have also been following discussion regarding these three generations of rights. And when we start with the UDHR and many other instruments, we'll find that there have been some developments in the form of Tehran Declaration, then Vienna Conference, which clearly makes it clear that all the human rights are independent, indivisible, and universal. So sometimes, there is some sort of conflict which is very apparent among the rights. So there is a need to prioritize the protection, like which right could be taken, in the first place, or which right could be prioritized. So this is a kind of dilemma which always come, but while saying that every right is indivisible, interdependent, and universal, it may thrust upon that we have to be very inclusive rather than, exclusively focusing upon first generation rights. So in this very context, I'm not taking that much time. I just want to bring forth this very context in which we are going to talk about. And this very panel will be a kind of reflection of three important trilogy, if I say, academia, judiciary, as well as from the sides of the practice. And that is a very good, synergy. And this synergistic reflection is not usually happening right now, which is a sorry state that we have to fulfill. And we have to be more and more interactive, and we have to be, sharing the platforms common to us so that we can proceed in this very direction. That would be very enriching for the legal evolution. So having said that, I will introduce briefly our guest. So I will be starting with Honorable Ms. Justice Geeta Mittal ma'am. And she has been our alumnus also of Campus Law Center. So that is another affiliation with her. And to just state few facts about her. Prior to her appointment as a judge, she had an illustrious legal practice in all courts and other judicial forums since 1981. She was appointed as an additional judge of the Delhi High Court on 16th July 2004 and was confirmed as a permanent judge on the 20th of February 2006. Her judicial pronouncements include judgments on compensation for right victims, a right to shelter of internally displaced person, a right to marriage of a lady member of the armed force, the appointment of a person suffering from disorder of sexual differentiation, so on and so forth. So she has radicalized the judicial, process in such a way where it is very much aligned to the access to justice concept, which is very akin to us also as a legal aid society. So she has also been recipient of Justice P.N. Bhagwati Award and 𝗟𝗏 Puraskar. Few of her judgments which are very catchy, very recent. One is Syed Tasadduq Hussain versus Union of India, where a division bench directed the government to ensure the legal assistance is made available to all the detainees under the Jammu and Kashmir Public Safety Act 1978. In addition to that, there was another case, 𝗤𝗏 Bhatt versus State of Jammu and Kashmir, where Honorable Court struck down Jammu and Kashmir Prevention of Beggary Act 1960 and held that it was unconstitutional and disproportionate infringement of the right to meaningful life, dignity, privacy, and liberty guaranteed under Article 21. So welcome, ma'am.
Thank you.
Now I'm moving forward to Honorable Ms. Aishwarya Bhatti, ma'am. Aishwarya Bhatti, ma'am, I mean, she is so popular that I mean, in Delhi and around, I mean, we are very much, I mean, taking her services in between also. She has been a regular visitor to our campus law center, delivering various lectures and taking part in various legal discourses. So Ms. Aishwarya Bhatti was appointed as Additional Solicitor General of India on 30th June 2020. She was designated as a senior advocate by the Supreme Court of India in March 2019. She was also Additional Advocate General of State of UP in Supreme Court from 2017 to 2020. She regularly participates in various television debates, deliberations, and national conferences on myriad legal issues of national importance relating to administration of justice and women's rights. She had also been panel lawyer of Supreme Court Legal Services Committee, Supreme Court Middle Income Group Legal Aid Society, and amicus curiae. So welcome, ma'am. Moving further, our third speaker, not in sequence, but otherwise, I welcome Mr. Prashanto Chandra Sen, who is a senior advocate practicing in the Supreme Court of India and Delhi High Court. He obtained his LLB degree from Campus Law Center. Again, we have some affiliation with our institution. And one thing I missed about Aishwarya Bhatti, ma'am, if you permit, I will just put one line to her, sir. So that was that she was adjudged as the best student advocate of the country in the All India Moot Court competition organized by the Campus Law Center only. So there again, you find some sort of, connection with all the three speakers, I mean. So moving further, I mean, Mr. Prashanto Chandra Sen went on to study for the Bachelor of Civil Laws degree at, that is BCL, at the University of Oxford in 1996. After working as an associate at Amarchand and Mangaldas and Suresh and Shroff and Company, he transitioned to a counseling and dispute practice in 1998 when he joined the chambers of Dr. A.M. Singhvi, Senior Advocate and former Additional Solicitor General of India. Subsequently, he joined the chambers of Mr. C.A. Sundaram, Senior Advocate in 2000. He began independent practice in 2006. He is now practicing in court and tribunals in New Delhi with a focus on commercial, competition, mining, environment, electricity, infrastructural, and public law matters. So there are diversified matters which he is looking into. He was a part of drafting committee for drafting the Scheduled Tribes and other traditional forest dwellers recognition of Forests Act 2006. So I most humbly welcome you, sir, to this very panel. Now I welcome to our own professor in charge, Professor Raman Mittal, sir, to this very forum. I'm very thankful to you, sir, that you have joined it. And before proceeding further, I will tell you to the audience that we will be going through the serial which has been provided to you in terms of, I mean, that very sequence. It will be starting through the Aishwarya Bhatti ma'am, and then moving to Prashanto sir, and then ma'am will be speaking in the last. So, and whatever questions you have, you just put it in writing and just address it to Q&A. We will be picking up those questions and then we will address with our panelists. So having said that, I welcome Professor Raman Mittal sir to give a prefatory note for this very webinar. So welcome to you, sir.
Thank you very much, Dr. Kshitij. Am I audible?
Yes, yes.
Okay, so Honorable Justice Geeta Mittal, Chief Justice of Jammu, Kashmir and Ladakh High Court, Ms. Aishwarya Bhati, Additional Solicitor General of India, and Mr. Prashant Chandra Sen, Senior Advocate, Supreme Court of India. My colleagues at the Campus Law Center and very dear students. We are extremely delighted that the Legal Aid Society of Campus Law Center has taken this wonderful initiative to organize a webinar on such an important topic, which focuses on the enforcement of human rights and exploring judicial responsibility for the same. In order to share my understanding of this extremely important theme, I would like to begin with a small anecdote. One day, a teacher came to his class with 100 pieces of cardboard. Then he placed them on the table and asked the students, look, this is the map of the world, and I have cut it into pieces, and I have mixed all those pieces together. Now anybody who is confident that he can put them in the right places and make the world map should come up. One tried, he failed. Another tried, he failed. One boy was watching 5 of his fellow students fail in their effort to make the world map complete and in order. Finally, he went and turned over all the cardboard pieces. The teacher said, "What are you doing?" He replied, "Please wait, I am working it out. 5 people have failed, but I found the secret. I have found the key." On the other side of the map was a picture of man. He arranged the man, which was far more easier a job to do. On one side, the man was arranged, and on the other side, the whole map of the world was automatically arranged. That was the key that the little observant boy could discover. The teacher praised the young boy for doing what he did, which others could not. Surely, he was able to find the key. My dear friends, today the whole world is suffering because of the simple reason that we are not looking at the reverse side of the world. It is man. It is when we start looking at the world through the lens of human rights that we can begin to heal the world. That indeed is the key. Well, the declarations and treaties of human rights basically mean that mankind still lives in many kinds of slaveries. Otherwise, there would be no need for all the declarations and treaties. The very need indicates that man has been deceived for thousands of years. Man has a right to dignity, to health, a right to grow, so that he can blossom into his ultimate flowering. This ultimate flowering is his right. He is born with the seeds, but the society does not provide him the soil, the right caring, the loving atmosphere, etc. On the contrary, society provides a very poisonous atmosphere full of anger, prejudice, hatred, destructions, violence, and war. On the surface, man has become civilized, but deep in the darker parts of his unconsciousness, he still needs to do a lot of work. Now, on the aspect of judicial responsibility for enforcing human rights, particularly the second and third generation, I would like to narrate an old Egyptian story. There was once a prince. His name was 𝗵𝗵𝗻. Although he seemed like a perfect prince, he was handsome, he was brave, intelligent, but somehow he was bereft of the sense of justice. If 2 people came to him over some dispute, expecting him to resolve the same, he would decide in favor of whichever one seemed most charming or more wealthy, or whoever had the best looking sword, or whoever could defeat the opponent in a duel. Tired of all this, 𝗵𝗵𝗻's father, the king of Egypt, decided to get a wise man to teach his son about the concept of justice. The king told the wise man, "Please take my son away and don't bring him back until he is learned about the knack of justice." The wise man left in a boat with the prince, but they suffered a shipwreck and ended up together as the only survivors on a deserted island. There they had no food, no water, which was ready-made for them. For the first few days, 𝗟𝗵𝗀𝗵 managed to catch some fish. When the old wise man asked him to share the fish with him, the young prince refused. However, some days later, the prince's fishing became less successful, while the old man was managing to catch birds almost every day. Just as the prince had done, the wise man refused to share his catch. The prince got thinner and thinner until he finally burst into tears and begged the wise man to share some of his food to save him from a certain starving death. "I will only share them with you," said the wise man, "if you show me you have learned your lesson." The prince, having learned what the wise man was trying to teach him, he said, "Justice consists of sharing what we have equally." The wise man congratulated him and gave him some food. That same afternoon, after the young prince had learned his lesson, a ship rescued them from the island. On their return journey, they stopped a while by a mountain, where a man recognized the prince and told him, "I am Max, the chief of Maximus' tribe. Please help us. We are having trouble with the neighboring tribe, that of the minimums. We both share our food, our vegetables, and we are arguing about how to share them." "Very easily solved," asked the prince. "Count how many of you there are altogether and share the food in equal proportions." Naturally, the prince was fresh on the principle of equality that he had learned on the island. But after saying this came a sound of thousands of cries from the mountainside. A horde of angry men came running over, and led by the chief, who was asked the question, they leapt on the prince 𝗟𝗵𝗀 and took him a prisoner. 𝗟𝗵𝗀 couldn't understand all this. He couldn't understand at all. They threw him in the prison cell and told him, "You tried to kill our people. If you don't solve this problem by daybreak tomorrow, you will stay in prison forever." Well, they had done this to the prince because the minimums were very small in size and numerous, whereas the maximums were enormous, but they were very few in number. So the solution suggested by the prince would have starved the maximums to death. The prince understood the situation and spent all that night thinking and meditating in the prison. The next morning, when they asked him for a solution, he said, "Don't share the food equally. Instead, share it out according to how much each person eats. Give people food according to their size." The maximums liked this answer so much that they released the prince, held a great celebration, garlanded him with gold and jewels, and bid him a good farewell for a safe journey. As they were walking along, the prince commented, "I have learned something new. It is not fair to give the same to all. The fair thing is to share, but you must take people's differing needs into account." The wise man smiled with satisfaction. So the second lesson was over. Already close to the palace, they stopped in a small village for the last night of their journey. And a man of very poor appearance received them and made sure they were well attended. Meanwhile, another man of a similar poor appearance threw himself on the ground in front of them, begging. A third man, who seemed to be a rich man, sent two of his servants to tend to the prince and the wise man and provided them with what they needed. The prince was so overjoyed because of the nice time that he was having with them that before his departure, he presented the villagers with all the gold that the maximum had given to him. Hearing this, the poor man, the beggar, and the rich man all came to claim their respective shares. "But how will you share it?" asked the wise man who was on a voyage with a young prince. The three are very different, and it looks like the one who gives away more money is the rich man. The prince hesitated. The wise man was right. The rich man had to pay his servants. He was the one who had spent all the money to look after them. However, the prince was staring. He was starting to develop a sense of justice by now, and something told him that his first conclusion on the matter was not sufficient. Finally, the prince took his gold and made 3 piles, one very big, another medium-sized, and the last small. In that order, he gave them to the poor man, the rich man, and the beggar. Saying his goodbye, the prince set off with the wise man, heading back to the palace. They walked in silence, and when they reached the palace gates, the wise man asked, "Tell me something, young prince. What does justice mean to you?" "I think justice lies in sharing, taking into account necessities, but also merits of the individual." "Is that why you gave the smallest pile to the troublemaking beggar?" asked the wise man. "Yes, that's why. I gave the big pile to the poor man who looked after us so well, despite being poor. In him, I saw both necessity as well as merit, since he helped us all he could despite being poor. The medium pile was for the rich man, even though he attended to us wonderfully, and he made all his resources available to us. He really did not have much need for the gold. And the small pile I give to the bothersome beggar, because he did nothing worthy of reward. He couldn't speak even 2 kind words to us. However, given his great need, it was also right to give him something to live on so that he survives." That's how the prince explained. "Now I think you will be a fine king, Prince 𝗵𝗵𝗀," concluded the wise man, embracing the prince. And he was right. From then on, the prince became known throughout the kingdom for his fairness, for his wisdom, and for his sense of justice. Some years later, his ascent to the throne was celebrated by all. And so it was that King 𝗵𝗵𝗀 became remembered as the best leader the kingdom had ever had. Well, friends, it is my proud privilege to welcome Honorable Justice Geeta Mittal, Ms. Aishwarya Bhati, and Mr. Prashanta Chandra Sen. Their remarkable erudition coupled with their rich experience will certainly guide us in our quest to understand justice and to apply the concepts of justice. Thank you very much.
Thank you, sir. We always need some stories to, exemplify what we try to understand. And you have made it very clear before us that how can we catch up these kind of, contexts. So in that way, I really appreciate your, anecdotal, citation. And now I will request Ms. Aishwarya Bhati to deliver a lecture on second generation of rights, second generation rights. So over to you, ma'am. Please.
Thank you very much, Dr. Kshitij. It is indeed a great privilege and honor for me to be here with all of you. Honorable Justice Madam Geeta Mittal, Chief Justice of J&K, Ladakh, for the trailblazer and dynamic, vibrant judge of our judiciary. We are also proud of her. My dear colleague, Prashanta, wonderful to see you on the virtual platform, away from our uniforms and not really attending to virtual courts. Thank you, Dr. Mittal, for such a beautiful story. I think you're a beautiful storyteller, and the context with which you brought in the story, I think it was really, really beautiful. Well, I want to start with quoting Dr. Ambedkar, what he said when, when the Constitution was being handed over by the Constituent Assembly. So he gave 3 warnings actually, and third warning is the warning that I want to read out. He said that on 26 January 1950, which was going to come, we are going to enter into a life of contradictions. In politics, we will have equality, and in social and economic life, we will have inequality. In politics, we will be recognizing the principle of one man, one vote, and one vote, one value. In our social and economic life, we shall, by reason of our social and economic structure, continue to deny the principle of one man, one value. How long shall we continue to live this life of contradictions? Well, not too sure how far we have come on this life of contradictions. But essentially, when I was not too familiar, I must confess upfront, I was not too familiar with this German principle of the second generation and the third generation rights, which Mr. 𝗟𝗡𝗵, the German jurist, had propounded. But it was interesting to get to know something. And then when I read more about it, it was interesting to note that because what was being called as second generation rights in 1977 by this German jurist is actually how the journey of our constitutional rights has been, if you see in the journey of our constitutional interpretation. So the second generation rights are rights with regard to, right to food, right to health, education. These are, after you have fulfilled the first generation rights, which are supposed to be the basic fundamental rights, the pivotal of your existence as a human being, then this is the second generation of rights, which is required for a person to live a life of dignity. So right to work, labor rights, legal aid, due process of law, fair trial, equality. These are some of the rights which are defined in the second generation rights. And I thought, let me take you through a journey of how the interpretation of these rights has differed in our constitutional journey by the constitutional courts of our country. And I must quote the famous trailblazer in her own right, the second judge of the Supreme Court of United States, who we just recently lost yesterday, Ruth Bader Ginsburg, RBG, also known as Notorious RBG. So for the reason that she wanted to compare herself with the famous rapper. And she was asked, how would she like to be remembered? How would she, what would be her inspiration that people should remember her by? And one of the very telling things that she says is, fight for the things that you care about, but do it in a way that will lead others to join you. So there, the remembrance for the famous RBG, who also said that the Constitution, as important as it is, will mean nothing unless the people are yearning for liberty and freedom. And bringing you back home, famously, Supreme Court has held fundamental rights are like empty vessels. Every generation has to fill in those empty vessels with the wisdom of its own times. So let's see how the generations have filled in its own wisdom and taken our first generation rights. They're ultimately all interconnected. So how the interpretations have taken the first generation rights through on a journey on to become greater realization for second generation rights and maybe third generation rights that my colleague Prasantoji will cover. Well, the first aspect that I do want to focus here is the privacy rights. Privacy, the journey of privacy started from the earlier judgment of 𝗏𝗏𝐺𝑒𝐿, which became the referral point in the recent battle under Puttaswamy, the Aadhaar judgments, where we saw a 9-judge bench had to be constituted because the earlier judgments were of larger benches. And the context in which Khadak Singh was given was completely turned, in interpreting the privacy argument that was being raised by the Aadhaar. I did have the privilege of representing one of the petitioners in the Aadhaar battle in the court. But there it was interesting, the judgment that came by the 9 judges in Puttaswamy with regard to privacy had a bearing not just on the privacy law, which was very, very clearly laid out. So why it had to be referred was because there was some disparity from Khadak Singh, but then there were subsequent judgments that had been passed with regard to, telephone conversations, with regard to, all kinds of issues, Nalsa, Ram Jethmalani, various judgments came in where privacy was remarked and acknowledged as a fundamental right. But then because it was a larger bench that was required, we saw 9 judges. And then what was the most interesting thing that the 9 judges did was, in addition to declaring privacy as a fundamental right, they went on to do something that was very, very interesting. And that something very interesting was to take away the basis of a judgment that had been almost like a stigma on the on the platform of the Supreme Court, a dark day for the Supreme Court, so to speak, the Adm Jabalpur judgment of the emergency time, where the Supreme Court had infamously reversed the findings of 9 High Court judgments. 9 High Courts in one voice had said that right to life could not be violated, but the Supreme Court reversed that, and a very academic bench of the Honorable Supreme Court Constitution bench, they went on to say that right to life can be suspended. Well, thankfully, our Constitution recognizes a balance of powers, the doctrine of checks and balances between institutions. So the 42nd Constitution Amendment did what the judiciary had, failed to do for the common citizen, and right to life was made inviolable. But the privacy judgment was significant because it declared Adm Jabalpur for the first time as a bad law, and they said that the entire basis of the Adm Jabalpur law was faulty. Another very interesting journey that we saw with regard to the challenge of the 377 section in IPC was, we saw that the Delhi High Court, in a very progressive judgment in Nas Foundation, struck down the constitutional validity of Article 377 of the IPC, and went on to say that it cannot it cannot pass the muster of constitutionality, it cannot pass the muster of arbitrariness, Article 14, Article 21. But in Suresh Kaushal versus Nas Foundation, the Supreme Court reversed that finding of Delhi High Court and went on to say that the High Court did not really have any business to interfere with that, and this amounts to reasonable classification. The judgment has very interesting reasoning. They said this amounts to reasonable classification when you are classifying on the basis of people on the basis of their sexual orientations. The judgment also gave a reasoning that because this is such a minuscule minority, so they gave this data that in the last 150 years that this section had been on the IPC, only less than 200 people had been prosecuted under this section, and therefore it's a very minuscule minority, and therefore the courts need not look at it, and at the most, if anything needs to be done, the legislature can look at it. Then we see the privacy judgment. Of course, Nafez Johar comes much later, but the privacy judgment was the judgment that dealt the death blow to this judgment also, and took away the basis and the reasoning of this, and then went on to say that this is because privacy was recognized now as a fundamental right, and a relationship between two consenting adults is protected as long as the relationship is voluntary, it is consenting, it is within the privacy of a home, it is a relationship which is protected under privacy. And they went on to say something very interesting, that because now it has been exalted and recognized as a fundamental right, privacy, therefore it does not matter whether it is a minuscule minority. Even if a single citizen is being denied of his right, then the constitutional courts will have to look at it. The another interesting, archaic Macaulay era provision of law, which was given the death knell recently, was also noteworthy to speak about. This is section 497 of the IPC, and the journey of section 497 is somewhat very interesting, because while in the case of Joseph Shine in 2018, the Constitution bench finally said that the manner in which adultery is defined as an offense under the IPC, where what is penalized is the sexual relationship with a man's wife without the consent or connivance of the man. So it was really a very lopsided definition, where if you had a sexual relationship with the consent or connivance of the husband, then it was not taken as an offense. One would find it surprising that why should this provision have been continued in our IPC for so long? Of course, Macaulay era law, like the rest of our IPC. But what is very interesting is that this provision was considered not on one but several occasions in our independent India, and the courts did considered it as early as in 1951 in Yusuf Aziz's case, and the Bombay High Court said that the immunity that is granted to women under section 497 amounts to a valid law under Article 15(3), which requires the state to have affirmative action for women. So they explained it there. Then we saw the Saumitri Vishnu's judgment in 1985, Revati's judgment in 1988. Both of these are Supreme Court judgments where they again considered the validity of Section 497 of the IPC and went on to say that, well, it is not unconstitutional in any manner. It does not strike at any of the Part 3 provisions, and it is a constitutional provision. Ultimately, it was only much later in 2018 that it was struck down as an invalid law. So this journey of these two interesting laws which have started, which were of the Macaulay era and the manner in which they were struck down, shows that how the constitutional provisions itself have been interpreted in a manner so as to, Constitution is often defined as a living document. That its interpretation must be dynamic. That it should be, we can't have a constitution which does not continuously evolve. While having a basic structure, we have to have the atrophy should not set in. It should not become fossilized in any manner. It has to have a continuous, vibrant interpretation that has to go on. Taking you to the earlier, the beginning of the Constitution, A.K. Gopalan was a matter that was filed soon after the Constitution was enforced. And A.K. Gopalan was an activist in West Bengal who was in custody pre-Constitution coming into force. So as soon as the Constitution came into force, he filed a writ petition and he said that now I have constitutional rights, and he was detained in a preventive detention. So he said, now I have constitutional rights, I cannot be taken away. And the court did not, the Supreme Court did not, did not give him any relief and went on to propound the theory of exclusivity of fundamental rights. They went on to hold that fundamental rights are exclusive. So if you're alleging violation of Article 14, at the same time you cannot say it's taking away my Article 21, Article 19, freedom, etc. Also, these are mutually exclusive. That was the theory that was propounded. Then it was much later in Minerva Mills and Maneka Gandhi when the court demolished this theory that was set in A.K. Gopalan of mutual exclusivity of fundamental rights, and went on to say that it's a trinity. Equality, liberty, justice. This is a trinity that's like a golden thread that runs through our Constitution. Fundamental rights are all interdependent and not mutually exclusive. And that is where we saw in Maneka Gandhi, of course, the due process was read into the law. Due process was something that was not prescribed in our Constitution. That is a phrase that comes from the American Constitution. But it was brought in a manner to say that Article 21, it's not to be applied just as procedure established by law. That procedure also has to meet the test of due process of being just, fair, and reasonable. So, and then of course the whole journey that the basic structure doctrine judgments, that whole line of basic structure doctrine judgments where Shankari Prasad, Sajan Singh initially, we have to bear this in mind that property to start with was a fundamental right under Part 3. So all the high courts, in fact, several high courts were interfering with all the land reform laws that were being brought in the independent India, and land reforms laws were important to be brought in at that time because India, primarily consisted of people who were in large numbers landless tillers. So they needed to be given ownership over that land that they were cultivating. So that, Sajan Singh, Shankari Prasad were those judgments when initially, and because high courts were interfering, so that is how the ninth schedule came to be born on the advice of the then Advocate General of Madras. He advised that we have to have a mechanism where the laws which are for, promoting social reforms are put in an umbrella where it is away from the scrutiny of the court. So initially it was meant only for land reform laws, and that is how Sajan Singh, Shankari Prasad, but then it was the dissenting judgment of Justice Mudolkar that ultimately became the pivotal point for the majority judgment in Golaknath, where now Golaknath judgment also comes in 1967, because by now the ninth schedule becomes all and sundry, and every law that has to be kept away from the scrutiny of the courts is being shelved in the ninth schedule very conveniently by the politicians. So then in this background, the Golaknath comes, and the Golaknath says it cannot be, Part 3 rights cannot be amended by the Constitution, and applies prospective overruling because otherwise it would have caused a havoc. Then ultimately in 73, we saw the Keshwanand Bharti judgment and the manner in which a balance was drawn in the doctrine of basic structure. Also very significant, what I do want to mention is the rights for realization of gender justice of gender empowerment and gender equality. That journey from my eyes, of course, slightly biased maybe, but I see a very different journey from my own experiential learning of that and my own experience of how my professional journey has been. And that journey is something, when we started initially, one of the first landmark judgments on gender justice was when one provision of the central government laws were challenged, where it was only a woman employee, she had to get permission from her employer for getting married. And that provision was not applicable for any male employees. It was applicable only for women. And the whole basis was that if you allow women to get married, then you are in a way allowing them to have then family, there will be biology, there will be physiology, and of course the Nargesh Mirza, Air India, the famous Nargesh Mirza case where the Supreme Court interfered to say that you can't terminate the services of air hostesses just because she has become pregnant. But that whole journey of gender justice, where some give and some take, but this whole journey, I see that one of the judgments that I had the privilege and the honor of being part of, that judgment is of 2020, where we were fighting a battle of parity with gentlemen officers for women officers of the Indian Army, Indian Air Force, and the Indian Navy. Those judgments, it was again the same kind of excuses that were given, that women are weaker in a physical sense, and they have greater duties, which are domestic duties, biological duties, matrimonial duties, motherhood duties. It was also said that our army consists of, the Jawans come from that social strata that they will not be able to take commands from women officers, and therefore we can't have women as commanding units. And it was thankfully thrown out in such emphatic terms by a bench of Honorable Justice Chandrachud and Justice Ajay Rastogi, and they went on to say that these kind of 101 reasons have no place, and they cannot be urged in any manner to take away the constitutional guarantees. They very emphatically say that this is a battle of the mindset. And it was interesting. We quoted Justice RBG in one of her judgments, because the 96th judgment of the US Supreme Court had struck down a provision by which there was exclusive entry in a military college just for gentlemen officers. So it was, and we had to bring it to our Supreme Court that the journey and the battles that women had fought, in the developed world in the 90s and 80s, Israel Supreme Court, Canadian Supreme Court, though it is unfortunate that that battle is being fought by women of our country, even in 2020. Well, unfortunately, on gender issues, the more things change, the more they remain the same. Gender discrimination transcends geographies. It transcends the kind of development that a country has had, the kind of governance that a country has. Well, that is the story how it is. But I think the role that our courts have played in transitioning these first generation rights to second generation and third generation rights, time is not enough. Of course, the spectrum is very wide. We have the right to health, environment. I continue to appear in the MC Mehta case of air pollution. It is a matter of, it's a writ petition of 1985. Despite judgment having been given, it is a matter that is continuing as a continuing mandamus judgment, continuing mandamus case where the courts are passing, directions from time to time to maintain the sanctity of the orders, and the manner in which everything has been read into the Part 3 rights. Courts did not wait for the Part 4 rights to be made into laws. Even before the 1987 Act of the Legal Aid Committee, laying down the statutory mechanism was brought in, the Supreme Court said even earlier in Hussain Ara Khatun's case, in Sheila Barsay's case, they went on to say that under trials, when they're languishing in jails for periods which are longer than, for the period that they would have undergone if they had been convicted of that offense. So free legal aid is something that is a constitutional mandate. And even before the laws could be framed, that's how, so courts have played, the constitutional courts of our country, I'm really proud to say that they have played the role of a lighthouse to our democracy, to our fundamental rights, to our Part 3 rights, which have very beautifully transitioned seamlessly into, you know, from first generation to second generation. And before I was really invited to this and I got the preface of what was the topic and the introduction to the topic, I was really not aware of these, the different 3 generations of rights. So it was interesting to note that even without knowing it, this is the journey that we have been undertaking, and so steadily we have been undertaking. I think I must end now. Thank you very much for allowing me to share my thoughts and views.
Thank you very much, ma'am. And it was a reflection of how the transition in different generation of rights can take place. So you'll see the beauty of judicial decisions, as well as it is the role of advocates also, how they put forth these kind of issues, which could be taken up by the judiciary, and through judicial innovation, we can catch up these developments. So I mean, that is why judicial innovation is a term which is so catchy to me also. I mean, very interesting to me, because as Justice Geeta Mittal is there, so if we follow, we will find that how through these interpretation we can have that very process on, and we are on the evolving track, catching up various kind of rights. So as you see the example of right to education, which was totally, I mean, put under economic, social and cultural rights, that has been, you know, accommodated under the part 3, as he has, I mean, Aishwarya ma'am has pushed it, that, I mean, touched it, that it could be, I mean, translated in part 3, if the judicial innovation and the efforts of the lawyers could be bringing. So thank you very much, ma'am, for this very, I mean, thoughtful reflection. Now I will be inviting, Prasanto Sen sir to deliberate upon 3rd generation rights, which are very common, I mean, and where it is a community right, so that becomes very, very important for the inclusive development of the humanity. So over to you, sir.
Thank you very much, Dr. Singh. Honorable Justice Geeta Mittal. Am I audible? Sorry.
Yeah, please.
Am I audible?
Yes.
Yeah. Honorable Justice Geeta Mittal, Aishwarya Bhati ji, Professor Mittal, Dr. Singh. First of all, I'm doubly blessed today, this evening. Not only am I being able to speak before my alma mater, which has invited me very kindly, but I also happen, and it had some of the finest legal minds when we were also studying at that time, that Professor MP Singh, Professor Moolchand Sharma, who unfortunately has passed away, Professor 𝗵𝗵𝗵𝗵. Unfortunately, Professor Tonika Sarkar had left by then. So I didn't get the benefit of her teachings. But there were great teachers. There was a lot of enthusiasm in the institution at that time. And the second blessing is to be there on the same platform as Justice Geeta Mittal, who has been throughout a model for us. First as a senior, always smiling, accessible, never losing her composure, absolutely perfectly delivering her arguments in court. And thereafter as judge, and then Chief Justice of the Delhi High Court, where she was continued her smiling demeanor, completely accessible, but tremendous, inexhaustible energy to do a lot of things in the Delhi High Court and to bring about a lot of changes. And today also, when we were just having a short discussion just before the program, the amount of work which has been done in J&K High Courts in terms of the institutional rules for arbitration being set in place, the mediation rules, etc. So we are. Also finally, it was in her tenure as Chief Justice that I was privileged to be designated. So I am indeed gratified and doubly blessed today. Now, as far as the topic today is concerned, an interesting topic, I would like to divide my speech into 2-3 parts. In the first part, I'd like to explore a little bit on the definition of 3rd generation human rights. I was also a bit uncertain about what exactly it meant when this topic first came to me, and therefore I went into it a little bit. So there's an interesting aspect of this which I'd like to highlight. The second part I would like to highlight is that in generation, so-called 3rd generation human rights, the primary function of the judiciary is to reason, to expound and declare 3rd generation rights. The judiciary has done an admirable job in doing so, and rightly has not agonized over whether it's a 1st generation right, whether it's a 2nd generation right, or whether it's a 3rd generation right. I'll explain why that is very important. At the same time, I feel at some level, the judiciary has lost a historic opportunity to be a torchbearer in this jar of rights jurisprudence. And the reason being, I'd like to point out some of the references in our own texts, ancient texts, which deal with these aspects of third generation human rights, transgender rights, not in terms of rights, of course, but they understand same-sex issues. They understand those issues. They are well understood. They are celebrated. They are, and therefore we had a rich source from which we could have drawn upon and been the torchbearers in this entire process. Instead, we waited till the West came out with its changes, and then we went ahead with it. So we lost a historic opportunity, according to me. And there, I will not in the judiciary alone in that same game as such, but I mean, we are on this side of the bench. When you get on to the judiciary, you have administrative responsibilities, you have other things to do, you have a large number of cases to deal with. It falls upon us lawyers, academics, to assist the judiciary. I'm sorry, I got disconnected. Am I audible again?
Yes, now you are, Prashantaji.
Yeah, sorry. So it falls upon us, legal practitioners, academics, all of us, to have brought forward material, brought forward petitions where the judiciary could have intervened, because the judiciary often cannot, on a regular basis, suo motu be taking up cases. So that was the second part. The important thing about today's third rights-based generation is that, first of all, a lot of young lawyers have done remarkable work in this area and have put forward petitions. And I remember reading a book by 𝗏𝐻𝐷 called People's Constitution. It talks about the first cases which came about before the Supreme Court when it started. And it had some really interesting cases. A prostitute, for example, filing a petition saying it's a right of profession and that should not be disturbed. But I do not recall, and I may stand to be corrected, any transgender or those such issues being raised before the Supreme Court at that time. Because at that time, the kind of issues which were raised related to preventive detention, which 𝐿 has expounded about, it related to land reforms. These were issues which Supreme Court was being approached with. So I think that loss of historic opportunity was a combination of factors. And I would then deal with some of these rights and how the Supreme Court has dealt with it. And the final part of my speech, I would like to just mention the historic challenges the court is facing today in developing the concept of fraternity. And the concept of fraternity has gradually now been touched upon in some of the recent cases. And it is an inextricably linked process of pluralism, which Dr. Singh was mentioning and Professor Mittal was also mentioning. And in this process of human rights development, that aspect has to be looked at, and there's an important opportunity for the Supreme Court and the High Courts, of course, to look into it. So first of all, starting with the definition of third generation human rights, this was coined in November 1977 by a very famous human rights scholar already mentioned by 𝐿𝐴𝐻𝐺, that is Karel Vasek, who was UNESCO's legal advisor. And at that time, the concept of third generation rights was mentioned by the director of UNESCO, one Amadou Mbao from Senegal. And that person is credited with coining this term third generation human rights. But there's a extensive critique of this coinage of this term, because one of the scholars, legal researchers and scholars, points out that there was no concept of first and second generation rights mentioned earlier. Vasek had to invent these concepts of first and second generation rights to justify his concept of third generation human rights. And there is a lot of problems with this conceptualization. What is third generation human rights? After all, if they are human rights, they are interlinked. We should not fall into the same problem in an analogy of reasoning I may take as A.K. Gopalan, as distributing rights in different silos. It is not like that. Human rights arise from human beings, they are interlinked. You cannot categorize them as first, second, and third generation human rights. On what basis are you categorizing? That is not clear. Number two, what is the time frame within which you would decide which is first generation, which is second generation, which is third generation? Now, initially, it is interesting. WASAC gave a time frame of 30 years, saying that the first generation began with 1948 Universal Declaration of Human Rights, followed by the two covenants in 1966 of UN, which all of you are well aware of. 2 years later, WASAC modified this theory and linked the three generations to the French concept of liberté, égalité, and fraternité, and therefore took back the enunciation of these rights 150 years back. So there was a lot of confusion on what is this first and second and third generation. And the alarm bell should have been rung in 1979 itself when this was done. Interestingly, Stephen, a scholar of the Danish Human Rights Institute, one Mr. Stephen, points out that this speech by which WASAC made this change is not available anywhere in the internet or anywhere else. And therefore, this was one problem. Second problem was the hierarchy in which the rights were placed. It put the French experience of rights jurisprudence, the American experience of rights jurisprudence on the top, when ignoring completely that transnationally, these aspects of human rights, if not in a rights form necessarily, but in some form or the other were there. And I will explain in the context of India how this arose. So therefore, I would like to say that let us not get into this characterization of human rights as first, second, and third generation human rights. We must link it to an interwoven aspect of human beings' personalities, which emerge, which are discovered. And in the process of judicial decision making, as they are discovered, they emerge. And it is interesting to note that even the courts have not fallen into this trap of categorizing the rights. If we see the recent judgments, the Puttaswamy judgment, the Nalsa judgment, the 𝗏𝐻𝐻 Singh Johar judgment, all of these judgments go on to the essence of human rights, which is dignity, autonomy of individual beings, because that's the constitutional philosophy on the basis of which the rights-based jurisprudence has arisen, that everyone is autonomous to make their choices. Everyone has a right to live with dignity, and there is a need to be tolerant of another person's idea of life, another person's expressions, as long as it does not, of course, affect public order and public interest. Now, if we look at, if we come to the 𝗏𝐻𝐻 Johar case, just to give an example of how they based the rights, because 𝗏𝐻𝐻 Johar, I would put in my scheme of things as part of your third generation rights which are there. And if we come to 𝗏𝐻𝐻 Johar, I'll just quote from there, because what is interesting is in this rights-based jurisprudence which has come up in a big way, number one, you've had young legal scholars, you've had, of course, well-established seniors and other advocates also, really churning out academic journals, churning out academic work, churning out petitions, dealing with these rights. And judges have risen up to the occasion in being completely up to date with all these aspects and really dealing with it. So the reason why I wish to refer to this judgment and quote some parts is it's just sheer beauty to read these judgments. I mean, when I was a law student, I remember reading judgments of Bhagwati, where it was so illuminating that it would leave a deep imprint in one's mind. And so are these judgments here. So at para 332 at 𝗏𝐻𝐻 Johar, the fundamental core of human rights it comes to, that the respect for an individual human being, and particular for his right to choose how he should live his own life, is individual autonomy or right of self-determination, which is a so-called third generation right. It is a right against non-interference by others, which gives a competent person who has come of age the right to make decisions concerning his or her own life and body without any control or interference of others. Lord Hoffman, in Reeves versus Commissioner of Police of Metropolis, stated, autonomy means that every individual is sovereign over himself and cannot be denied the right to certain kinds of behavior, even if it is intended to cause his own death. Then we may come to para 437 in this same judgment, sorry, yeah, para 437, where I will just read out. Sorry. So para just a minute. I'm sorry. I have some problem with this, getting this. Yes, sorry. Para 333. It says, it mentions that under our constitution, the inherent value which sanctifies life is the dignity of existence. Recognizing human dignity is intrinsic to preserving the sanctity of life. Life is truly sanctified when it is lived with dignity. There exists a close relationship between dignity and quality of life. For it is only when life can be lived with a true sense of quality that dignity of human existence is fully realized. Hence, there should be no antagonism between sanctity of human life on the one hand and the dignity and quality of life on the other. Quality of life ensures dignity of living, and dignity is but a process in realizing the sanctity of life. A life of dignity comprehends all stages of living, including the final stage, which leads to the end of life. So the point which I'm making again is that we have to keep in mind the fulcrum of human rights jurisprudence, which the courts, even as late as in the recent judgments, have highlighted again and brought out again, which is autonomy and dignity. And even Justice Geeta Mittal's judgments, for example, the judgment which relates to removing, to declaring certain provisions of the Beggary Act as unconstitutional, was based on this concept of dignity. The other aspect where Justice Geeta Mittal has, of course, espoused as far as third generation rights are concerned is that in international covenants one can look forward to come about with what are the areas in which third generation rights can be expounded. Then, of course, we must keep in mind one more aspect as far as categorizing rights as first, second, and third generation is concerned, that it leads to a form of legal formalism, which must be avoided as far as possible. And here again, I will just read para 409 in 𝗔𝗱𝗃 Jauhar case. And he, of course, here, of course, he talks in the context of reasonable classification, Article 14, the fact that, there is a formula that rational nexus, which is sought to be rational nexus with the classification seeks to achieve, that nexus should be there, etc. But the court warns that when you come to understanding fundamental rights, you should not get stuck with formulae and formalities. And here it is mentioned that the problem with the classification test is that what constitutes a reasonable classification is reduced to a mere formula. The quest for an intelligible differentia and the rational nexus to the object sought to be achieved. In doing so, the test of classification risks elevating form over substance. The danger inherent in legal formalism lies in its inability to lay threadbare the values which guide the process of judging constitutional rights. Legal formalism buries the life-giving process of the Constitution under a mere mantra. What it ignores is that Article 14 contains a powerful statement of values of the substance of equality before the law and the equal protection of laws. To reduce it to a formal exercise of classification may miss the true value of equality as a safeguard against arbitrariness in state action. As our constitutional jurisprudence has evolved towards recognizing the substantive content of liberty and equality, the core of Article 14 has emerged out of the shadows of classification. Article 14 has a substantive content on which, together with liberty and dignity, the edifice of Constitution is built. Simply put, in that avatar, it reflects the quest for ensuring fair treatment of individual in every aspect. So therefore, I will not, at the risk of again reiterating the point further, the great role which the judiciary has played in enforcing human rights, and now I'll say human rights, not necessarily third generation human rights, is to eschew this formalism of first, second, and third generation human rights, not really go too much into it or be distracted too much by it, but to go to the heart of the matter. And ultimately, it is justice by heart at some level, which is the most important thing in human rights jurisprudence and enforcement. As far as right to environment is concerned, already 𝐿𝐵𝐺 has dealt with it, but I will again just make a short reference to it. The concept of continuing mandamus which the Supreme Court evolved. And with the Godavarman cases which took place, it played an incalculable role in, and in fact, the Forest Survey of India's recent report shows how forest cover increased over years as opposed to earlier. Corporates, and I have dealt with cases in environmental law which have been there, started taking environmental rights, protection, legislation seriously. Earlier, it used to be seen as just a unnecessary evil which could be circumvented in some way or the other. But when the Supreme Court started taking environmental rights seriously, that was the first time. I mean, even all these corporates and all these institutions which were there had to take it seriously. And today, it is a serious issue which is there, which needs to be taken into consideration. Of course, the second round of litigation is about to start in the courts because the recent environment impact assessment notification which has come out, there is a lot of criticism of it. And again, the courts will be seized with this debate, and it will have a great role to play whichever way it goes. As far as the RTI is concerned, again, there have been great developments. High courts have played a very important role in giving a very expansive content to many of these rights. There have been situations where there have been conservative interpretations of the right also. But you know, it's a mixed bag. It's part of the judicial interpretation process. There are some where it is taken in a progressive way. In some places, it may take a very conservative role. One thing I think when the RTI rules were formed with respect to each of the high courts, I say this with ignorance of procedures. Maybe it was done, but I would have. May have been a good idea if all high courts had a kind of a joint meeting to discuss the kind of rules which should be there for RTI purposes for each of the different courts, because there are different kind of rules in different courts. Delhi High Court has a very progressive set of RTI rules which are there. But for example, I think it's Meghalaya or Sikkim. For an RTI application, you need to pay 500 rupees, which makes it very difficult for many people who may be otherwise not well equipped or well endowed financially to make applications for RTIs. So there's a divergence in the kind of rules which are there all over the courts for accessing information from the high courts. So I think a coordinated effort in enforcing these rules may have been a useful case. There are, of course, various cases which are there of RTI jurisprudence which I don't need to go upon. The Ram Jethmalani case, the Rafale review case, which made it much easier for applicants of RTI to access information. Now I come to the other part of my lecture, which is the opportunity lost by the legal system in totality, because I wouldn't call it the judiciary, because as I said, it is a joint effort which has to be there, and we are equally to blame. And that is that we overlooked. We were perhaps aware, but it did not engage our attention in the initial periods when it could have. And here I would recommend everyone to read a fascinating book called The History of Desire by Madhavi Menon, a professor in this area. And it's fascinating to note how our Indian traditions viewed these aspects. For example, there were advanced notions of sexuality. Kama, which is the god of desire, is actually bodiless, known as Ananga, without any limbs. The famous story, of course, is that Shiva, when Kama tried to disturb Shiva in his meditation, which led to Shiva burning Kama down in anger with his third eye to ashes. So Kama became without any kind of limbs. And the symbolic significance of this is that Indian thought did understand that desire is everywhere. You cannot circumscribe desire in particular forms and formats. It can take all kinds of forms. And you have only to see the temples of 𝗏𝗏, the Sun Temple of Konarak, or other Hindu Jain temples which are there, Hindu and Jain temples which are there, in which life is celebrated in all its myriad complexities. There are all forms of sexual expressions which are there, ranging from all kinds of, including to bestiality, if I may add here. There is same-sex intercourse, which is there. There are all kinds of things which are celebrated, which was accepted. People were comfortable with this idea that yes, desire will take all kinds of forms and it has to be there. And when I read the 𝗔𝗏𝐺 Johar case, when I read the Puttaswamy case, not so much Puttaswamy, but the 𝗔𝗏𝐺 Johar case, the transgender case, Nalsa case, which is relating to this, what else is it but to, for us to recognize this? And this was already there in our traditions. What must also be realized is, for example, if you look at in Ramayana, Ram is described as Purusha Mohana Rupaya, as so handsome that even pleasing to the sight of men. And that showed the kind of advanced maturity with which Indian tradition viewed even sexuality and expressions of sexuality. Then you have desire rampant running across Hindu traditions in Kalidasa's Kumara Sambhava, which has erotic literature going into great detail about various aspects. You have the famous, and here I think I have my wife to thank, looking at gender and sexual identity. We have the case of Vishnu transforming into Mohini. When you talk about sex change today, you have Vishnu transforming into Mohini. You have Bhishma Pitama laying down his arrow before Shikhandi, because Shikhandi was Amba in his previous life, which was a woman form. And Bhishma had taken a vow that he could not attack a woman. I'm not anyway advocating that at that time advanced forms of surgery existed where you could have sex change and all. It was human imagination and which was working at that time. But what I'm trying to point out is the maturity of Indian thought at that time. And it is a pity that we were not able to draw upon this. And we may not entirely, it's not necessarily that why we didn't engage with it. I kept thinking about it these last few days. One of the things which struck me was that the Judeo-Christian concept of morality was a very restricted Victorian concept of morality. If you talk about homosexuality, which has been discussed in the 𝗔𝗏𝐺 Johar case as being outlawed, it took place sometime when the penal code came in with Macaulay. Eunuchs were criminalized as a tribe during Macaulay's time. Otherwise, in the Ramayana, eunuchs are given a special blessing by Ram, because they are the only one who remain even after Ram goes off into exile and comes back. He tells all the townspeople to go back. It's the eunuchs who remain there. They wait till he comes back. And Ram gives them a special blessing and says that your blessings, whenever you give any blessings, will carry a significant power and weight. Which is why even today in all important occasions in society, when they come to your house, they give blessings, you are expected to give certain things. But our maturity got mixed up because of the Judeo-Christian concept of morality, which came through criminalizing these eunuchs, hijras, etc., these transgenders, and again same-sex interactions were criminalized. And therefore, this led to a situation where I think there was an initial hesitation to engage with these in the thing. So I feel that opportunity may have been lost for various reasons beyond our control. And now, of course, we've come a full circle as we see Western thought developing on certain lines, and we take upon it, we go forward. Finally, as far as enforcing this is concerned, we come to the transgender persons protection of human rights, which has been recently brought out, the act which has come up, 2019, which is before the Supreme Court. It's going to be an interesting case to what extent and how the state can intervene in determining whether a person is a transgender or not. What is interesting, of course, to be also noted is that in the Nalsa case, Justice 𝗔𝗏𝐺 does make a reference of the fact that hijras, eunuchs, transgenders, etc. are to be elevated to the initial respect that they enjoyed in society, which shows an understanding about the maturity of Indian thought prior to the British rule, when eunuchs were not criminalized. So that is as far as the act is concerned. And finally, I'd like to end my lecture by talking about what is the future which lies ahead of us, and the immediate problem which is there is polarization, is increasing intolerance between various communities and tensions which are arising. And this is fueled by the media. And I'm saying not media in the sense that media comes up across with certain stories. One is, of course, that why it picks up certain stories, why it tries to make it more of an entertainment rather than any kind of negative news. It's a whole array of entertainment of negative news because you want to catch eyeballs, because it is run by corporate structures where you need advertising, and for kind of attention to be got, the structure of the media as such, it is promoting that kind of a thing. The second part is that things like the algorithms, etc., which are working in WhatsApp, in YouTube, in Twitter, our algorithms are adept that when they see what kind of program you're watching, they'll give you more and more of that same program. So if you're used to watching a particular kind of thought process or a particular kind of lecture or a particular kind of this thing, you'll get more and more of that. And therefore you will go on re-emphasizing your view more and more. And you will think that everyone else is also seeing the same thing, which is not the case. Someone else is seeing something totally different, which is catering to his viewpoint. This leads to greater chances of polarization in society. So according to me, Supreme Court today and the High Courts today, the constitutional courts today, face a humongous challenge where you will have people, actors coming into before the courts thinking that the other person is completely stupid, has no idea what he's talking about, is completely bereft of reality, little realizing that the person who's come forward himself is in a cocoon about a reality which has been propagated by algorithms in a particular way. And in that context, I think the concept of fraternity, which is extremely important, which you must keep in mind. And that fraternity has been zeroed in by the Supreme Court recently, for which I would just like to point out para 375 of Navtej Johar case. And I'll end with para 375 and 472 and 473. Para 375, it says the Constitution brought about a transfer of political power, but it reflects above all a vision of society governed by justice. Individual liberty is its soul. The constitutional vision of justice accommodates differences of culture, ideology, and orientation. The stability of its foundation lies in its effort to protect diversity in all its facets, in beliefs, ideas, and ways of living of her citizens. Democratic as it is, our Constitution does not demand conformity, nor does it contemplate the mainstreaming of culture. It nurtures dissent as the safety valve for societal conflict. Our ability to recognize others who are different is a sign of our evolution. We miss the symbols of a compassionate and humane society only at our peril. And at para 472 and 473, if I may just put forward, sorry, para 473, morality is one, and however important it may sound to some, it still is the only one element in the composition of values that a just society must pursue. There are other equally significant values which our democratic society may wish for. Then again, equally important is the need to foster tolerance of those who hold radically differing views, empathy for those whom the economic and social milieu has cast away to margins, a sense of compassion, and a realization of innate humanity which dwells in each human being. Value-based education must enable our young to be aware of the horrible consequences of prejudice, hate, and discrimination that continue to threaten people and societies the world over. So this concept of right of peace, which is a third generation right, which has been put forward, is extremely important today in the context of the structure of the media I've explained. It's a neutral technological structure in the context of the polarization which is taking place. And one must remember one more thing. This also we have great traditions in society, in our society, Indian society, which dealt with this concept of fraternity. And one of the greatest is King Ashok's edict after the War of Kalinga, where he talks about peaceful coexistence, which is one of the most important things. And one of the emblems, as we see, is the Ashokan pillar, is the emblems. And I sometimes feel that our constitution makers who were there were people who were steeped in Indian tradition. They understood what it was. They chose this emblem. Perhaps there was a hidden message there that sometime or the other you must explore your Indian thought, your Indian traditions, and come forward with the jurisprudence which is there. And let us hope that as far as peace is concerned, we look to the great King Ashoka for his edicts. Thank you very much for listening in peace, patiently. Thank you.
Thank you so much, Prasanto sir. And few things I gathered from your elaboration. One is that a very hardcore compartmentalization of all these rights is not required. They are required for academic discussion. If you are going into getting into the evolution of it, or how that has been figured out, that is okay. But if we just practice it in that straight-jacket fashion, I don't think that we can achieve our aim, as you pointed out rightly, that it is spill overing. It is a kind of thing which we have to take in the perspective of touching the core, as you said in your words. So rather than just aligning with that very categorization, we have to just go through the core of that very right. So in that way we can do that. And the next thing which you pointed out rightly, that fraternity is a term which is being used in our preamble. But how many discussions are going on fraternity? That is a question which we have to think about. We talk about equality, we talk about other facets of rights, but we don't talk that much about fraternity, which is needed to be discussed more. So that is a very good thing which you have highlighted. And you have covered all the important aspects of third generation of human rights or rights, whatever we can say. And in that way, the approach should be, as you said, to touch the core rather than just glorify this kind of right, this generation of right, or that generation of right. So there are some potential obstacles which may be you may be encountering, or judges are always being encountering, by how to look at it and how to approach it, so that its enforceability could be ascertained. So that is a thing which we have to look into. And for that very thing, I think Honorable Justice Geeta Mittal is the right person to reflect the judicial reflection and review these rights in her first-hand experience, if I say. So I'm just inviting Professor Geeta. Sorry, I'm so sorry.
No, that's all right.
Honorable Justice Geeta Mittal, Chief Justice of Jammu Kashmir Court, and she has been, in due course of time, whether she has that very position or not, she has been reflecting a new kind of, a dimension to this legal arena that will be benefited from various kind of approaches, which may be more pragmatic rather than, just a dead letter on the, any laws. So over to you, ma'am, and welcoming you to this forum.
Thank you very much, Kshitij ji. Dr. Raman Mittal, Kshitij, of the student leaders of the Legal Aid Society of the Campus Law Centers, Prasanto, Aishwarya, dear students, so much has been said about the rights and the history and all the Supreme Court judgments on the topic. All of them have not only been cited, but also excerpts have been read out to you. So I'm not going to repeat what has been said, but adverting to the topic, you have asked us to comment on judicial responsibility in enforcing second and third generation rights. So I will take the clue from what Professor Raman Mittal, led us into. I'll make this anecdotal and share a few experiences about the difficulties and our responsibility in enforcing these rights. But before I take you to my experiences, some of my judicial experiences have been told to you, but a couple more I'd refer to. But I would like to emphasize that this division of rights into first, second, and third generation is very, very significant. And as Prasanto has pointed out, I had the year as 1979, Prasanto, and Karel Vasak was Czech. I think Aishwarya got him as a German. And he began this articulation of rights at the International Institute of Human Rights in Strasbourg. He derived his articulation from the watchwords of the French Revolution, as Prasanto said, and emphasizing that the liberty as first generation human rights, equality as the second generation human rights, and fraternity as a third generation rights. And, I would say, Aishwarya, that all these rights, have to coexist. One flows from the other rather than, there being in absolutely clear-cut compartments. You can't have one without the other. So actually, this articulation commencing from liberty to equality and flowing into fraternity actually is a flow, if you see, and it's a very, very significant articulation. The first generation rights have been referred to as blue rights. The second generation have been referred to as the red rights, and the third generation rights have gone into fraternity has been read into as the green rights, and we already have the commencement of fourth generation rights, where we have begun talking of the right to exist digitally, the right to digital identities and digital reputation, which are very significant. So, as I said, that one flows from the other, and it's also an evolution of not only social evolution, but also technical evolution, because when we are talking of digital identities, digital reputation, and digital existence, you're actually talking of the 21st century world, where we are talking of, existing in clouds and information being stored in safe custody, safe spaces, and the internet explosion and the way technology has taken over. So actually, one is growing and one is flowing from the other, and all these rights have to coexist. Now, having said that, and I think we have the formulation of the first, second, and third generation given by both my very learned speakers, very experienced speakers, and I'm very impressed with the extent of knowledge, that you have brought out. Aishwarya, your articulation of the manner in which the Supreme Court has interpreted the Constitution or misinterpreted it initially, has been phenomenal, and I'm very impressed, truly. But, some very, very basic rights, for instance, the first generation rights, liberty, and participation in political life, I don't think we need to say much, but it included freedom of speech, freedom of religion, property rights, right to a fair trial, voting rights. And at the global level, this is where those treaties which Prashantho referred to, the 1948 Universal Declaration of Human Rights, the 1966 ICCPR, the International Covenant on Civil and Political Rights, and the 1953 European Convention on Human Rights, was a recognition of these first generation human rights. The second generation human rights relating to equality were fundamentally and are fundamentally economic, social, and cultural in nature. These guarantees, they guarantee different members of the citizenry equal conditions and treatment. They impose upon the government the duty to respect and promote these rights. They include the right to employment in just and favorable conditions, right to organize and bargain collectively, right to education, right to food, housing, and healthcare, as well as social security and unemployment benefits. And they were also covered by the covenants which I've referred to, the UDHR, and embodied in the 𝗖𝐶, in the International Covenant on Economic, Social, and Cultural Rights. In India, so far as the court's response was concerned, we are aware of the phenomenal jurisprudence on each of these rights. The Olga Tellus, which held that the right to life included the right to livelihood, and the right to livelihood was not absolute, and deprivation of this livelihood could occur if a just and fair procedure was undertaken, and the government's action must be reasonable. Then the right to legal aid, that is, the constitutional guarantees under Article 38 and 39A. I had occasion to consider the impact of the entry point court fee. The Delhi government in the year, it in 2014 or 15, enhanced court fees in Delhi 400 times without an upper limit. And all the bar associations in Delhi and a couple of lawyers had filed writ petitions challenging the validity of this increase. And I had occasion to examine this, a very detailed examination, and not an easy subject to deal with, because there was a huge issue between the challenge was to the legislative competence of the government of Delhi to even undertake this kind of a legislative exercise. But what had really struck me very hard, and I think the interesting examination was to be able to hold a legislation unconstitutional on the ground of the irrationality, and the what was done was the disproportionate impact, adverse impact of this court fee on women's access to justice. I had examined, undertaken a huge exercise of examining the impact on access to justice of court fees, and had found that it was an absolute barrier to large categories of people in coming to the court because of their inability to pay the court fee, especially women. For instance, a woman who's looking to file a claim for maintenance under the Hindu Maintenance and Adoption Act, the court fee valuation is 10 times the annual maintenance that she was claiming. And she had to pay court fee on this kind of a suit valuation. And it would be impossible for a woman who did not have the means for maintenance to have the money to pay the court fee. But this was a right which we had opportunity to examine. You've all talked of what we did for detainees in Jammu and Kashmir. Right to education, 𝗔𝐿𝐴 has talked about. The Supreme Court recognized this as a fundamental right, led to a constitutional amendment, and Article 21 (A) was brought on the Constitution, and it has led to a legislation as well, resultant legislation to fine-tune the implementation and the guarantee which the Constitution ensured. The manner in which the Supreme Court has extensively dealt with the right to clean air, water, environment as an essential concomitant of the right to life has also been discussed here in great detail. There has also been recognition of the right to adequate standard of living and live with dignity as part of Article 21, right to life. We're also aware of the famous words of the Supreme Court that right to life does not mean a mere animal-like existence, but it encompasses a holistic, composite, formulation of all that goes into living, And, the judgment, the beggary judgment, which has been referred to, I had occasion to deal with the Bombay Beggars, Maharashtra, Begging Act, which had been implemented in Delhi. Bombay Beggars Act it was, just before I was leaving Delhi, and we had struck down the constitutionality of that. But I had occasion to examine a similar enactment which was in existence in Jammu and Kashmir, and had the time and space to undertake a more comprehensive, examination of the issues raised. And we had looked at begging from several perspectives under the Article 21 rights of dignity and the entitlement to everybody, but also as an essential part of freedom of expression, that what does a beggar do? He's in a sense actually conveying his plight, and it is his method of conveying his plight and his pitiable condition which had been criminalized, and we had struck it down as completely unconstitutional. I understand, and the railways is undertaking a suo motu exercise to take away provisions under the Railways Act which criminalize begging on trains, on railway properties, as a result of our consideration. So it's been, I think, a very empowering moment for the poor people who have had to resort to begging as a source of their basic means, for their essential living existence. The third generation human rights are those that go beyond civil and social, and again are the subject matter of many progressive documents of international law. These are part of the 1972 Stockholm Declaration of the UN Conference on the Human Environment. They're also part of the 1992 Rio Declaration on Environment Development and other pieces of generally aspirational, what is known as soft law. These are also known as the solidarity human rights, that is collective rights, that are rights that go beyond the framework of individual rights and focus on collective concepts such as community or people. So this term is categorized under what are known as green rights and houses an extremely broad spectrum of rights, including the group and collective rights, right to self-determination, right to economic and social development, right to a healthy environment, natural resources, right to communicate and communication rights, right to participation in cultural heritage, right to intergenerational equity and sustainability. So actually, if we look at the formulation of the rights, you will see, notice that one flows into the other, and they all have to coexist to give a meaningful existence to mankind. And again, all the, we have heard all these, the enunciation of the, summation of the judicial pronouncements and the active role that the Supreme Court has played, especially in recent times, well, not in recent times alone, but on different rights, right from the time 1950 when the court came into existence. So, the recent judgments have taken us, miles ahead of where we were, and as Prashanto has articulated, that actually culturally we were far ahead of times. When Ramayana was written, when all the beautiful art and the culture, 𝐄𝐍𝐅𝐼 and all these structures were constructed, and perhaps we were a more evolved society then than what we developed into. Perhaps what was the result of the so-called development was the result of the strife in our society, the aggression that India was seeing, and the way we were marauded by plunderers from across our boundaries, across the boundaries, and the shackles under which India was existing. And perhaps they emerged, the distortions in our communities and societies emerged because of the pressures of the subjugation that Indian society had from the foreign rulers. Now, just a few issues on judicial responsibilities, and enforcement of the rights, And since I'm talking to a legal aid society, so, this is something that I talk about very extensively, and it's a subject which is very dear to me, that is access to justice. And I keep on talking about it, and I like to talk, and I do it, repeat it, so that what I have to say goes out to as many people as it can. What I've always said is that, you cannot treat access to justice synonymously as access to courts. There's a huge gap, and from the manner in which these rights have evolved and the subjugation which the Supreme Court has addressed in 2020, the subjugation of transgenders, the subjugations of the LGBT community, the criminalization of their autonomous decisions, and the absolute deprivation of their right to privacy, is proverbial, and this shows that and how long it took for these people actually to reach the courts to seek justice, and enforcement of their rights. As even enforcement comes long after recognition, and they had to fight for decades together to even get to have the court recognize that they had any rights. And enforcement is still a far cry. I have a PIL in the courts in Jammu and Kashmir, High Court of Jammu and Kashmir, filed by transgenders seeking enforcement of the Nalsa judgment. And it's needed very strong monitoring to even get the forms of educational institutions modified to include the clause for the other gender. Now I've been asking for status reports as to how many transgenders have been admitted to the schools, and I don't let go. So I list the matter every 15 days, and to so to ensure that it reaches out. In Delhi, just to give them a space and give them visibility, I had given employment, temporary employment, which was the only thing I could have done, to transgenders as well as acid violence survivors in the High Court, and because they were so spurred in society and not accepted. So, I had put them in very visible and public spaces. For instance, I had them in the inquiry section, at the reception in the High Court. I had them manning the wheelchair facility, which I had put out for disabled. You could book a wheelchair in advance if you were a litigant or a lawyer needing a wheelchair in the High Court. And I had a number and all. So I had a transgender who had the physical strength to do it. And I had used them in visible places so that they got acceptability, society and community accepted them. My law researcher in Jammu and Kashmir is an acid violence survivor. She was a litigant who came before me seeking the government assistance to pay her medical bills. They had undergo repeated surgeries if you have faced acid violence. So she's a very bright acid violence survivor who's a law student. And after she finished her law, so I have engaged her as a law researcher here. But I just want to talk to you about how difficult it is. We've recognized rights, but enforcement is another story completely. So, I'll tell you about, there are some cases which leave their impact on you. And I would never forget the face of this one litigant. I was sitting as a single judge in Delhi High Court in 2006 or 7, judge of only 2-3 years vintage then. And there was this case where, as is very much a norm, the respondents tried to overtake the brief. So I had the MCD lawyer yelling at the top of his voice that this case had to be thrown out. So I said, why? Because he said, it's barred by delay and latches. It is barred by limitation. So I said, in writ petition, there is no limitation. So he said, no, he's talking about an allotment made in 1978 to him. And we are in 2007. He's come after 30 years, so he can't be given any relief. So I said, I'll come to you. Let me hear what the petitioner has to say. It was the case filed by an old man who said that his house, his tenement in the Turkman Gate had been demolished in 1976. And in the rehabilitation, that was during the emergency demolitions. And in 1978, he was recognized by the government as entitled to rehabilitation. And they had given him a slip, an allotment slip, which, and despite his entitlement being recognized, he was not being given the property, his house or what. So, but the lawyer, the man was obviously very poor, the petitioner. His lawyer was pathetic. So I had to turn to this litigant who was standing in the court, an old man, white-haired, white-bearded, with folded hands, wearing a skull cap. And so I started talking to him in Hindi. He obviously couldn't understand English. I said, Baba, kahan the aap? He says, घर तोड़ दिया, सड़क पे पड़े थे, accident हो गया, 5 साल अस्पताल में थे. So I said, परिवार कितना बड़ा था? He said 6 children and me and my wife. So I said, कारोबार क्या था? He said, एक furniture repair करते थे उसी property में. So I said, कितना बड़ा था वो property? It was a 7 feet by 10 feet shack, So in one stroke of the demolition, this man had lost his right to shelter, a fundamental right under Article 21, and his right to livelihood. Everything was gone. And then there was the MCD lawyer yelling hoarse that he didn't even write a representation. He should have come to the MCD. I said, when you did what you did to him, he must have been looking for the nearest tree under which he could find shelter for his family. He wouldn't have known where to get food. I'd asked this man if he had educated his children. So naturally, he said, there was no question. He says, roti khane ko paise nahi the, school kahan se bhejta? And then 5 years in Holy Family Hospital. So, I held ultimately, to cut a long story short, I said that you cannot defeat fundamental rights by delay and latches. And I said, here was a recognition of this man's entitlement by the government. It was the government's responsibility to find him and ensure that they delivered what they had promised him, that is the allotted flat, and they must do it within a time-bound period. A judge decides a case and then you don't know what happens to it. But somehow this case, it bothers me till date, the fate of this family. And till I got a law researcher and I was telling him about this story, just educating, sensitizing them as I do all my law researchers. So, and I said, I always wonder whether the MCD complied with that order or they went in appeal. So he said, ma'am, let me check. Now today we have technology, it's easy to do. And I found that by a 2-para judgment, my order had been reversed by the division bench on the ground of delay and latches. So, I always worry and think, as a judge, you shouldn't think what happened to your case. I'm not bothered about my case, but I worry about the 6 children and this old man and his wife as to where they were, which streets there are, and I can't do more about it. But what I want to point out is that this case has left an impression on me, not only because of the harsh facts of the case and the harsh circumstances of the family, but Turkman Gate must be 2 or 3 kilometers from the Delhi High Court. It's not even 2 kilometers from the Supreme Court. And it took this poor man 30 years to walk those 2 kilometers or 3 kilometers, And when you talk of access to justice, and this is, you're talking about Delhi. I'm not talking of the interiors of Jammu or Kashmir or the tribal area of Himachal or the, mountain areas of, and the tribal areas of the Northeast. But I'm talking of the capital of India, that it takes 30 years for a poor man to walk 2 kilometers to the court, What must be the fate of the deprived and the people asking for enforcement of rights in other parts of the country? So, it's been my mantra, I say this to every law student, I say this to every lawyer, and I tell this to every judge, that, do your best to ensure that your justice, your courts become accessible spaces, and they don't remain inaccessible to those who need them the most, And you cannot fault this family, this man, from approaching the court 30 years late, It is not his fault, but we were so remote. He must have. Now, what are the barriers to accessing justice? It is not only his physical condition that he was in, and I was hospitalized, but he must not have had financial resources. He would have no knowledge of the law. He would have no knowledge of courts or legal institutions, And, approaching lawyers by itself must have been such a barrier, it must have been so difficult for somebody. And we all have an innate fear of institutions, of the police, of the courts, of lawyers, of judges, of anything that is official, So, and if you talk of women with family problems, there are even bigger barriers. The family is the barrier. नहीं, उस घर में शादी हुआ है, उधर से तो अर्थी निकलना चाहिए, तुम ऐसे नहीं, वापस जाओ. Society, अरे उसकी बेटी का divorce का केस है. So, social ostracization. So there are so many barriers that people face before they come to the courts. So when you're talking of judicial responsibility, I think the first and foremost responsibility is ensuring that we make our courts accessible spaces. The second thing, I think we are really late. I'll just give you 2 instances, and then I'll close. Is as to how we as courts, make our courts and systems inaccessible. There was a bomb blast in the Delhi High Court, and these are all real life examples. I'm talking about Delhi. I'm not talking about Jammu and Kashmir. There was a bomb blast, and after that, immediately we had to put in regulations, entry regulations into the court. The bomb blast was outside our gates, and we put in a gate pass system. One day, there was a case, not in my court, but there had been a case where a husband had challenged an order made under section 125 of the CRPC for maintenance. And the court held that unless husbands pay the amount of audit, they can't challenge the order in the court, in the higher court. Now this order, somebody else, another petitioner after this judgment another husband filed a petition, and the single judge said, no, this you have to first pay because you have to comply with this previous judgment. Now this man didn't have the money to pay, and the single judge also felt it was too onerous a condition, so referred the question for consideration to the division bench. that's how this matter came before me. I was sitting on the criminal bench. I was sitting on a DB with Justice Midha. And I told the husband, no, you have 3 children and your wife is not a working woman. You all have to pay. You have to pay something. He said, the petitioner's lawyer said, my client is a laborer working on daily wage basis somewhere in Uttar Pradesh. He can't pay. So I said, will you look at resolving this matter? He said, yes. I really used to push family matters for mediation, for resolution, and I used to work very hard at resolution in whatever jurisdiction I've sat till today. I still do it, even I'm at the verge of retirement. But wherever there's a family matter, and I've succeeded very greatly in this. He's agreed to the mediation, to mediate, and we fixed a day for his hearing. The day the hearing was fixed for the personal appearance, the wife was sitting in a court, very tardily dressed, sunglasses and everything. She was wearing a burqa, but she had her children also with her. And we called out the matter, the wife, children, and her lawyer there. The husband's lawyer was not there. We passed it over. And second call, husband's lawyer was there. Everybody, so the petitioner was there, and petitioner's lawyer was there. That's the husband. Wife, everybody was there. No husband. Again passed over. The man said, the lawyer said, he's coming. He's getting his gate pass made. Till 4:15, nothing happened. The husband, no husband. So we told him, you're lying. So he said, no, he's not. He's getting a gate pass made. So he kept the case the next day. Next day, we were told that the man was not given, his client was not given access into the court because he did not have a photo identity. So I asked the lawyer, I said, did you not identify? Because the form requires the lawyer's signatures, that identifying the person. And they said, no, even if the lawyer is identified, still, unless you don't have a photo identity, they won't let you come into the court. I said, but they take your biometrics and they take your photograph. Still, you need a photo identity. And this man was a laborer who did not have a photo identity. We've talked about privacy and Aadhaar and all this. And, but there is this huge body of people in this country still who have no photo identity, and who are on no registers whatsoever. There is no recorded identification of lakhs and lakhs of people in our country, and so therefore people like this will not have access to a courts, even though the lawyer is identifying, even though you're taking fingerprints, and even though you're taking biometrics and photographs. So, I thought this needed an order that if I have asked for somebody to appear, then because of this court requirement of a photo identity, he can't come into. And, we disagreed on, I held that you can't insist on a photo identity. My brother, Justice Midha, did not agree with me. He thought I'd gone overboard and beyond the permissibility and treated this as, he said that this was PIL jurisdiction. I felt that ensuring appearance of a litigant in my court was the responsibility of the court concerned. But it went to a third judge who agreed with Justice Midha. So this rule exists till date, and no lawyer has challenged it, that you have to have a photo identity, and I had read that your courts have open courts. You have to be available open to students, to law teachers, to researchers, to anybody who wants to see your court space. But this is where we as a court have put in a systemic requirement, which is a barrier to access to justice. The third thing, then that's the last thing, we are hitting 7 o'clock and it's pitch dark in Jammu and Kashmir. I don't know what it's like in Delhi, but children must be fed up. What I want to talk about is victims of sexual violence. Again, where access to the court, presence in court, or whether does the complete secondary traumatization of a victim of sexual violence. So a rape victim, is asked to come to court and testify, give her deposition, standing shoulder to shoulder with the perpetrator. This is absolutely unacceptable. And the most traumatic experience of her life, a woman is being asked to talk about standing in the presence of the the perpetrator, humiliated by defense counsel, and subjected to all kinds of character assassination, victim blaming, etc., in such a public space. So, I undertook a huge exercise for this, and we, in recognition of the fact that having uniform procedural requirements, having a uniform requirement of testifying in like this can be a barrier to justice. It's actually it brings injustice to the victim of sexual violence. So I had done a huge study, and in 2012 September had inaugurated the first vulnerable witness deposition complex in the country. And this was in the 𝗓𝗏 courts without any budget. We had reconstructed an existing courtroom and created a facility where there was no interface between the victim of a sexual violence case, a rape victim, and the accused. And this facility was replicated in Delhi. And before I left in 2018 August, it had been replicated in all the district courts except one. And more than almost between 5,500 to 6,000 victims had walked through this. I've replicated it in Jammu and Kashmir as well. And we have this facility. But this is another huge barrier, that court procedures are also a huge barrier to access to justice. And I think rest we don't need to talk about. There's no time to talk about, but this is, access to justice is something that is very, very dear to me. And in times of COVID, I'll close here. I just leave this thought with you. We are talking of virtual courts, and it's wonderful to be sitting virtually and having an opportunity to talk to Dr. Raman Mittal, Kshitij, Prashantho and Aishwarya after all these months and days, and see them as well, and to talk to all of you who have joined this program. But virtual courts, and virtual e-filings are working very well in the constitutional courts, in the high courts and the Supreme Court. But we have to really look at ensuring that we can work the system in the trial courts. The criminal justice system is facing a huge problem. Production of accused, in serious crimes requires a lot of security people to travel with them. There are defense lawyers, there are prosecutors, there are police personnel bringing files to the prosecutors, there are witnesses, and it's very difficult to maintain social distancing norms. It's even more difficult to do e-trials, in most trial courts in the country. There are very few which will be e-enabled, then to connect with forensic science laboratories and hospitals, with doctors in hospitals, which also is possible, but where to get private witnesses and how to get them to the court in this situation of the pandemic is proving to be a huge challenge. So we are doing remands digitally. You're able to do bail applications there remotely, but the other trials, etc., in family cases and criminal trials is proving to be a huge challenge. And we, judges and lawyers and academicians, can all get together and contribute very valuable thought, so that we can ensure access to justice to the most deprived in these very difficult times. Thank you very much, Dr. Raman Mittal, Kshitij Singh, and the Law Society of the Campus Law Center for giving me this opportunity.
Thank you, ma'am. Thank you so much.
I'm sorry, may I just interrupt one thing? Ma'am, I just wanted to tell you, you had taken up a case suo motu of sexual harassment by a doctor who was practicing in America, if you may recall.
Yes.
And he was convicted there, and then he came back to India and he was practicing here. And that was taken up suo motu. I wanted to just inform you of that case. Ultimately, of course, that person's license was taken away. But more importantly, the Indian Psychiatric Association, which has the most advanced best practices, rules on how to, of the doctor-patient interface, how it should take place. That has been adopted by the MCI in that case, which you had to leave midway. So that today, I think we've got, MCI has amongst the most advanced, forms of interaction which are there.
Just 1 minute more, Dr. Mittal. I just want to share with you that just after I came here, I was sworn in on 11th August, and I think it was mid-September, I had passed a judgment on a case where a person was running an employment agency, and he was sexually exploiting young girls on the pretext that he would get employment. Similar to what is actually instance of Me Too in the rest of the country. So I had written a judgment, and I had drawn extensively from international jurisprudence and asked the government to look at sextortion as an offense. And we got the law in Jammu and Kashmir. We could have special enactments. So sextortion, SEX, like extortion, is an offense in Jammu and Kashmir, punishable with imprisonment up to 3 years. The definition of rape has been amended, and 𝐸thly, a clause 𝐸thly has been included to include consent which is obtained in such circumstances as the Me Too movement is covered under the definition of rape. So we are the only place, not only in India, but the central government has saved that clause, but anywhere in the world where sextortion is an offense. And this is the second judgment which I wrote, which resulted in legislation. A 2007 judgment I wrote on rape, was cited by the Verma Commission in 2013 in 16 pages in its report. And it led to a lot of the criminal law amendments, so it's been a, a good journey. And the court fees, which was quashed, remains quashed so far in Delhi. But this judgment, Aishwarya, you should see. You should see the Jammu Kashmir rape law. We are the only place in the world where sextortion is an offense. And you're grappling with what to do with all these Me Too cases all over the country. But if it had happened in Jammu and Kashmir, it would be considered rape.
So thank you so much, ma'am, for reflecting all these practical intricacies which are involved in enforcement. And I mean, you are thinking, Judge, I mean, transcending your capacity to, feel those kind of things, obstacles, that how it could be, I mean, dealt with. And the other thing you have made, the thing is that we as a society, whether we were more adjustable in the past and now we are becoming more aggressive and, more assertive, if I say. So that we have to look into. If you permit, we will just take 5 to 7 minutes for a few questions and then I will wrap up.
All right.
Okay. So I'm just, clubbing these 2-3 questions which are there. And one is about the right to internet, whether it could be made a fundamental right or so. And particularly one of the students is asking about the Jammu and Kashmir also. So what do you think? What is your position regarding that? And the next thing is that are there times when court has exceeded its limit to accommodate the second and third generation rights within the fundamental rights realm, whether that is a proper exercise of that jurisdiction or not? And the other one is that implementation of duties, what you think that's more important than rights or something. And last one is, what do you think that legal aid, whether it should be made mandatory on all lawyers to make it more effective or something? So these are the few questions, and it's open to you and other panelists also. So if you just go ahead.
So far as what is commonly termed as a judicial overreach is concerned, there are occasions which can be considered as, which have been considered as the court having overstepped the contours of separation of powers. But so far as where it's necessary, we see the court's, expansion of right to life. And if this hadn't happened, what all we would not have had, The court has recognized a host of rights as essential parts of the right to life, which are so badly needed, Now, now you look at the unwillingness of the legislature to correct such rank injustice, This is reading down of section 377. The legislature was unwilling to take it off the statute, and a legal norm which was created by the society actually deserved to be at a particular stage. It was required to be recast and removed, So if the court hadn't stepped in, so much injustice would have continued, Now the similar thing, but you look at the court's judgment in Visakhapatnam. It is internationally celebrated. There's a gap in statutory law, and the legislature recognized it, took 13 years to carve the law. So, so here, I think the court's role was indispensable and it was absolutely essential. But there are certain policy areas where, we have to be a little more careful. For instance, where a budgetary allocation is necessary to work the judgment or the right which is created, and there are certain technical areas and expertise which the court doesn't have, where the court has to be a little careful. Also, the enforcement, we have to look at enforcement mechanisms. We create a right, but we can't enforce it. It could be difficult, and sometimes, the a judgment of the court, by, some activists come to court and the court pronounces a judgment. As a result, society becomes very complacent, I can't think right away, probably Aishwarya will be able to guide on this. But, for instance, we saw recent, I don't know, I'll leave it to Aishwarya to expound on these. I don't want to say this, but so far as internet and fundamental rights are concerned, the Supreme Court has said internet is a fundamental right. And there is regulation on security, on grounds of security concerns in Jammu and Kashmir. And again, the Supreme Court is monitoring that. So it may not be proper for me to comment on that. But legal aid, as we need to encourage it as much as we can. But recently, the last year, the government has cut down the budget very sharply. And this year, we'll see a bigger problem with the pandemic consequences. So there's been a huge impact on availability and to legal aid in the country. And let's see how it pans out and how it works out. But Aishwarya may like to comment on, and Prashantho.
I'll just take from where Justice Mittal has left. Ma'am, in my opinion, I feel that, PIL litigation was all great in the initial decades. But I think the problem has arisen where we have publicity interest litigations taking over the PILs. So PILs still serve a very important purpose despite the statutory mechanism of legal aid being there since 1987, and the breadth, length and breadth of legal aid has now transcended to every district court in the country. But it is important that PILs are still undertaken only qua the underprivileged, and not on, ma'am was absolutely right on policies issues or contractual issues, or, there is a problem, because then either it becomes a publicity interest litigation or there is some vested in that, and those kind of determinations have a problem area. So, and I think, yes, all lawyers must volunteer for legal aid. It's not required to be mandatory, but it's a matter of great pride for the volunteers. I say it very, very proudly on my CV when I say that I've been a legal aid lawyer from the beginning, and it gives immense. In fact, it's better. You want to help somebody, and you have the whole mechanism of the legal aid committee screening where the legal help is required. So I think all lawyers, all law students, you already have now these legal aid clinics and legal aid bodies which are very, very robust. For example, CLC, and now this is a mechanism that is there in all law schools, but I think more and more lawyers should volunteer here.
I don't have anything to add. I think it's been covered well by both ma'am and by Aishwarya.
Okay, so I will be just giving a formal vote of thanks to allow me to do that. So I'm on behalf of Awaaz, the blog of Legal Aid Society Campus Law Center, would like to take this opportunity to place on record my hearty thanks to our speakers, Honorable Ms. Justice Geeta Mittal, Ms. Aishwarya Bhati, and Mr. Prashantho Chandra Sen for their cooperation and for offering critical insights. And thank you for gracing us with your presence. I'm profoundly grateful to our professor in charge, Professor Dr. Raman Mittal, for his unconditional support and guidance. And most importantly, the people behind this very backdrop, in the backdrop. So those volunteers, so I must pay heed to that. An event like this cannot happen overnight. The wheels start rolling weeks ago. They were just, making connections with you and reconfirming your availability. So it requires planning and a bird's eye for details. I have been fortunate enough to be backed by a team of very motivated and dedicated students. I just want to name them few. I named few of them. So one is Vasudha, then Lauleen, Raghav, Siddharth, Mishba, and Dutch. So these are the students who were very much, behind the scene. Next, I wish to thank our technology partner for the event, that is 𝗵𝗵 for their assistance and acknowledge the support rendered by the team. I'm thankful to all faculty members, students, and other participants who have attended this webinar and expressed their thoughts. So with this, we will be concluding this, but with this very promise that we will be engaging you again and again, because this is a one kind of thing which is pretty distinct, if I would say, or explain why it is so attractive to all, because here all the three, main segments of our legal arena or legal fraternity, like lawyers, judges, and academics, are on the same platform. So this is a thing which always encourage the, enrichment of the literature and interaction, so that we can solidify our legal jurisprudence. So this is a huge, I can say that this is a huge initiative, and with the help of our 𝗖𝐶, Professor Dr. Raman Mittal, we will be again engaging you in a different program, so that we will benefit, get benefit from you, and from different perspectives. As you know, Professor Geet, I'm always, surrounded by professors, so it is always in my mind. So I'm sorry for that. So Justice Geeta Mittal or Ms. Aishwarya Bharti or Mr. Prasanto, they have different perspectives to share with. So we as an academic, we do have different perspectives. So if we have a synergy, so we can create and enrich our judicial, you can say, system as well as our legal system. So on this very note, I am thanking you all from the bottom of my heart, and with the promise that we will be engaging again. Thank you so much.
Thank you. Thank you so much.
I also just thank CLC for this. Thank you for this invitation. Just one quick word about my interns who helped me out. I must mention that
please.
Muskan Nagpal, Adila Begum, then Raksha Sharma, and Gurmeet Singh, they all were very enthusiastic in working. I normally mention their names. I should have done it at the end of my speech, but I just thought I must put it across. Thank you.
Thank you. Thank you, and goodbye. And see you soon. And see you very soon. Thank you. Bye-bye.